we're going to have somebody on the stage who's going to discuss and demystify 7 most important myths in IP. She is somebody I know for 7 years already, I think. We met, I think, at one of those Garage 48 events in Riga. She is a mother of 4, and she has been in tech law for 10 years. So she will take really good care of you if you go to her. Please welcome on the stage, Ingrīda.
Thank you. Thank you. Thank you. Good morning. Thank you for the very nice introduction. My name is Ingrīda Kariņa-Bērziņa, and I have to say I do a lot of public speaking, and I don't usually get very nervous, but it's very hard to follow these pitches. I thought they were really polished. They're really good, and they don't have a safety blanket like I have, which is a paper. So maybe another round of applause for all those brave people who pitched. I thought they did a great job. Okay, so a little tiny bit of practical advice and law, which I hope will be of use to the founders. 7 critical intellectual property issues for founders. I've been told I need to kind of point like that. I am here because of a wonderful institution called the Riga Graduate School of Law, and here is a picture of one of the recent graduating classes, I'm pointing, which is a law school which is not a typical law school because it teaches interdisciplinary programs: law and business, law and diplomacy, law and finance, transborder commercial law, European international law, and it is located here in Riga. And the reason that RGSL is here at this conference today is because RGSL is launching an LLM program, Law and Technology, this fall, which is the very first program of its kind in Latvia, and which will be aimed at people in the technology community, to lawyers, but also to business people looking to gain their expertise. So stay tuned for more information about applications. The RGSL team is here, and on the second floor, they're hosting coffee. So they have asked me to come here today because I am an RGSL lecturer, among other things. And what I'm supposed to do is kind of talk about what I talk about in a way that's a little bit of a taste of what teaching looks like at RGSL. As you can hear, I'm from the US. I grew up in Wilmington, Delaware, which is where everybody's company is incorporated, and actual factual people live there, like me. I went to Yale as an undergrad, something called the Fletcher School of Law and Diplomacy for Masters, and I did my JD at Penn Law. I am a partner at a law firm here in Latvia called Cobalt. We are 180 lawyers in 4 countries, and I practice intellectual property and technology law. And I do quite a lot of teaching and lecturing. Tech Hub, which is the foundation whose conference we're at today, I do pro bono legal advice there. And as I mentioned, I teach at the Riga Graduate School of Law. So let's start, with a true story. In 1988, Rolls-Royce was up for sale. And there were several potential purchasers of this legendary company and this wonderful brand. And Rolls-Royce was not too pleased about the fact that Volkswagen ended up being the winning bid. But that's what happened. Volkswagen paid $712 million for this company. However, somehow, in one of those moments, which I think all the people involved were utterly puzzled by later, the trademarks of Rolls-Royce were not specified in the deal. So what was the outcome? The outcome was a billion-dollar mistake. BMW, who had been kind of perhaps Rolls-Royce's preferred purchaser, but who couldn't come up with the money for the deal, BMW ended up with these trademarks, and Volkswagen, who spent all this money, didn't buy what they thought they bought. They ended up only with the Bentley brand. And the takeaway from this is what's not in the deal is not in the deal. But founders, of course, are smarter than that. And maybe this is the sort of mistake that can happen in a giant deal with lots of super well-paid lawyers, huge deal team, right? If it's a founder, you're going to be very careful and very smart because it's your baby and it's just you and your investors without a big team in between you and them. So starting points are this, that for a tech company, the main assets are probably intangible. This is your intellectual property, your trademarks, your patentable inventions, your designs, your copyrighted works, including your software and your know-how. In real life, even very sophisticated and smart companies do mess up, but you will be different. And I would say that from experience, what I see among startups, perhaps, is that there is a lot of advantage and benefit to being a little pedantic and very systematic in taking care of your IP, in identifying it, in protecting it, in handling contracts, in getting everything in the company's name, and, if needed, in taking action against others. So what are these 7 key IP issues? 7 is a sort of a magic number. Fits in well with the time we're given. You could probably say there are 3 or there are 15. But from experience in the field, I would say that these are 7 typical issues that bear paying attention to. The first is, do you know what your IP even is? Second, do you own what it is you think you own? Third, what do those employee contracts look like? Fourth, do you know about other people's rights? Fifth, have you protected your stuff? Sixth, confidentiality. And 7, enforcing your IP rights. So, first issue is identifying what is the intellectual property you have. And I think for many companies in the founding stages, you're very busy with the kind of nitty-gritty, everyday operational issues of just making your thing go and getting it to your customer, and then getting your deck ready to go talk to people who you would like to get money from. But along the way, it's very important as kind of basic business housekeeping to know what your assets are. Do you have software programmed by you or for you? Are you using other people's software? Your marketing materials, written descriptions of your stuff, those are all the kinds of works that are protected by copyright. Trademarks. What is the name of your company? What are the names of your products, your domains? You can run into an awful lot of trouble in not taking this seriously, in not being at least a little bit thoughtful about how you're choosing your name and how you're registering your domain, because for all of these different kinds of rights, first in time is first in right. And if you happen to pick something which is confusingly similar to somebody else, and somebody else has the means to give you a hard time, you will have a big old fight later that you did not need to have. Design rights are an area that startups often don't think about, but there are relatively cheap, easy ways of protecting things like graphical user interface, things like the appearance of products. There is legal registration for the appearance of products. And fourth thing, and probably in terms of investment needed and trickiness of protecting, the biggest one is inventions and know-how. Do you have any inventions that you are patenting now or could in the future? Do you have proprietary methods that you need to protect the secrecy of? So that's all very dry. Let's look at a specific example. Your humble mobile phone is laden with intellectual property, and the numbers are really kind of mind-boggling, that inside this fabulous little device are about 1,500 to 2,000 patented inventions. Wow. This is a really massive number. And those inventions cover things like these data processing methods and the semiconductor circuits, chemical compounds, et cetera, et cetera, et cetera. There are registered, ooh, does this have a clicker thing? Oh, it does. There are registered designs in the shape of the phone and the shape of the icons. In 2012-13, what was the big story in the headlines having to do with mobile phones? Who was battling whom because of copying off the registered design? Samsung, Apple. And ultimately, there was a $1 billion judgment in one of the many, many cases against Samsung in the United States. But what was it that they had ripped off? It wasn't even all the groovy stuff inside the iPhone that makes it so awesome. It was just the outside shape of the tablet. Because Apple had registered its design for the shape of the phone, the shape of the tablet, the shape of the icons, and the layout. And the court said, you know what? It creates the same overall impression on the informed user. You lose. Third example, in a mobile phone are the registered trademarks. And you see trademarks everywhere you go. A trademark is nothing more than a sign indicating origin of goods and services. The purpose of a trademark is to decrease or eliminate the possibility of confusion in the marketplace so that there is a clear and indisputable link between trademarks, right? TechChill, you see that mark, that name, it links to a specific event. LMT, this is a beautiful trademark, I must say. This is what is called a combined mark because it combines words with visual elements. This mark leads you to Latvia's mobilized telephones and only to Latvia's mobilized telephones. So there are many of them. Of course, in your mobile telephone, they are owned by lots and lots of different people. Whoever has made the handset, whoever is making the software, whoever is offering those icons. But there also are trademarks and all kinds of interesting things like startup tones. Trademarks do not only have to be visual. And finally, copyright. Copyright protects software, ringtones, images, visual content, text, and everything. And the key takeaway about copyright is that just because something is available or published online and there are no technical obstacles to get it, doesn't mean that you can or should use it. About 2 months ago, I had to act on behalf of a company who had hired a web designer to make a web page. And this web designer had found some images on some website, someplace, and on that website it said, images free to use, images copyright free, something. So nobody thought anything, of course, and this lovely image was on the company's website. And what happened, a photographer, through his Los Angeles law firm, sent my client a cease and desist, and we did some research, and it looked like it was pretty credible that they would actually file suit. And the company said, it was on the web. It just was a right click and a copy, and you stick it on the website. But it doesn't change the fact that the photographer had been very smart, had hired a law firm, had put up something where they're monitoring usage of the images, had registered all those images with the US Copyright Office, and the client was out of luck, ended up having to settle for more money than you would think reasonable, but it was the only alternative to a lawsuit. So you have to be a bit thoughtful about both about your own stuff and about other people's stuff. So, second issue, do you own what you think you own? The fact that you have employed people to create IP, they are programmers, they are designers, they are making a graphical user interface for you, they are designing some groovy product, or if you have contracted their services, it does not automatically mean that you own it. Wonderful example here. I wish we could make this, is it possible to make it a bit darker? No? All right. I don't know if you can see, everybody recognize who this is? This is Mike Tyson. And does anybody remember this movie? Hangover. Was it second one? Second Hangover. So we love the Hangover movie franchise. We especially love it after a couple of beers at Forum Cinemas. Silly movies. But the awesome story in the movie, of course, is that does he wake up on his wedding morning with this tattoo on his cheek? But there's a legal story behind this, and the legal story is as follows, is that Mike Tyson got this tattoo from a tattoo artist who had a very good lawyer, and the tattoo artist had Mike Tyson sign a waiver acknowledging that the tattoo artist retained rights in this design. The fact that it's on Mike Tyson's cheek doesn't mean that Mike Tyson owns the design. And when they made this movie, as we know, Mike Tyson actually had a little cameo role in the movie. And Mike Tyson was psyched that there's this kind of dweeby actor with his tattoo on his face. But prior to the release of the movie, the tattoo artist turned up and said, "You, Warner Brothers, you want to release that movie, you have to pay me my license fee for use of my copyright, which is this design." Classic example of you may not own what you think you own unless you have, is that counting up or down? Up. Unless you have contracted for it. So, and next part of that issue is get everything in your company name. Okay, in the early days, it's catch as catch can. You're on that site buying the domain, you stick your name in, right? Then you have a trademark registration, you put in the name of whatever it is on your credit card. You're doing things in a harem-scarum way just because that's how it happens. However, it is smart and cheaper to fix all that stuff early up. Make sure you've got contracts with everybody, all the people who are working for you, all the people that are contracting, all the founders, to say that all this stuff, all this intellectual property is granted to the company. If there's no contract and no transfer of right, there's no rights. So you get your friend, your classmate, whoever, to design something for you. And as sometimes happens, you're just like hanging out, you're drinking coffee, and they're doing the thing. If there's no contract explicitly saying that the rights to that design go to you, they don't. They don't. And this is not where you need to be. Of course, we know it's like weird to like be all lawyerly and paper-like with your friends, because they are your friends. But for the protection of your business, this is very important. All this kind of stuff, these trademark registrations and patent filings and domain name registrations must be in the company name. I have acted both for founders and for investors at the stage that there's an investment going into the company. And I am amazed by the number of times that you're kind of like, it's going to be closing tomorrow, and it turns out that, I don't know, the entire domain portfolio is in like the guy's girlfriend's name, or some other kind of a key thing which needs to be fixed beforehand. Good idea to think about that as early as you can. And the reason that this matters is that you cannot make money off of stuff that doesn't belong to you. You cannot license it. You cannot put it into your product. You cannot do all those things. Of course, you can, and people do, but you do not want to be in a vulnerable position where your whole business is resting on content, for instance, or designs or products where others could say, well, actually, I designed that. That was my logo. That was my whatever. It belongs to me. So, issue 3. I've already mentioned contracts, but they are so important that they bear repeating again. Very simple. Get all those beautiful contracts in some sort of order. I have seen, and I think everybody who has dealt with these sort of transactions has seen, You see all kinds of crazy stuff. You see businesses that are really at the stage where they're already really talking to outside investors who are not related to them, and they have no contracts at all, none. There's nothing at all tying all those stuff that's programmed, the product, the concept, the names, to the company itself. You can have contracts that don't mention IP rights at all. And what happens is that you can have, again, at the point that somebody is willing to put money into you, you have to redo all the employment contracts with everybody, which is not the worst thing that can happen. A more worse thing that can happen is the second one, is you have to get waivers from previous programmers, right? The guy who was with you, he was like hanging, he was doing stuff, now he's off in Singapore or wherever, and you've got to track him down, and you've got to get his signature on it, because in the due diligence, when your investor is putting money in, they want to know that there's not somebody out there with a possible claim against you in the future. So, and another issue is this. Very often, early stage startups are being run by... Time is up? Okay. In that case, then we will go, do not have people working for you. Do not have people working for you who are also working for somebody else unless you have looked at their contract. Many employment contracts say that everything people do all the time, day and night, belongs to the employer. Do not be in this position. We may go to the third to last slide, please. Because cleverly, I have summed everything up. 7 points. Take control over your IP earlier. This is cheaper and easier than sorting it out later. Figure out what you have, get it in the company name, get your employee contracts in order, develop a strategy to protect your portfolio, have a strategy for dealing with potential problems with others, keep secrets secret, enforce your rights if you need to, and doing all these wonderful things will make you attractive to investors and will help you make lots of money. Thank you.
Hello. Thank you so much. I think you will be around.